we look great, Jim. Who fashes it? Is it the fast wings up a foot? What through Shane to put on your press, will you?
What's that?
I don't look like that, do I?
Well, I hope I look a little bit like that.
That's not me.
Well, it's not me either. Genova Burns has been serving the corporate community for over 35 years. As John Quincy Adams once said, he who tells the best story wins. So here is our story. My name is Bill Heller. I'm of counsel to the firm of Genova Burns, and I specialize in intellectual property and technology law, among other things. I'd like to introduce my friend Jim Kirkos, who is the chairman of the Meadowlands Chamber of Commerce.
We're here to talk to you today about the perils of artificial intelligence.
Artificial intelligence, as you know, has many, many uses. And as you can see from the video, we were able to take the bodies of soccer stars and put them in our jerseys. That was a violation of several intellectual property and privacy rights. Let me give you an example. As you probably have heard, the name, image, likeness fad has crossed college sports. Name, image, likeness is a new term for what we used to call the right of publicity. Each of us has rights in his or her image, name, and likeness. And we just used those images, those likenesses, those names, perhaps without permission, except that this is an educational video and we are able to do that based on an educational exception to the intellectual property rights at issue. It's dangerous to use artificial intelligence. Let me give you just two examples. One comes from the legal area. Several lawyers at a case in federal court in New York submitted a brief with 5 case citations. They had gotten those citations through artificial intelligence. The judge and the judge's law clerk found that they were fictitious. They didn't exist. And the judge fined the lawyers $5,000. In AI terms, those cases were hallucinations, meaning they don't exist. And AI can create hallucinations which could make the AI user, you in your advertising, for example, liable for many things, including false advertising. Or you could be sued for infringement of intellectual property rights. Jim, do you have any comments on this?
Yeah, I think today is this video is all about showing how easy it was for someone to use artificial intelligence for what you talked about, copyright infringement and image infringement. And I think while AI is here to stay and we all need to learn how to use it, we also need to learn how to protect ourselves, and we need to understand how to do that, what are the ramifications when we want to use it, and what are the ramifications if it's used against us.
Right. The fact of the matter is that people are advertising more and more now because of the World Cup coming to our area in 2026. FIFA and its FIFA logo with the World Cup trophy are registered trademarks owned by FIFA, and probably also the logo is copyrightable subject matter. So what does that mean? If you want to advertise to be connected with FIFA and the World Cup, you can't do it unless you have permission from FIFA, which entails a sponsorship agreement. All that is a license agreement that says you have paid for permission to use the name of FIFA, the logo depicting the World Cup trophy in connection with your business. Trust me, that will be an expensive sponsorship agreement. Yeah, Jim, how are you helping local businesses with this issue?
Well, first of all, we're doing lots of information sessions like this to make sure small and mid-sized, especially small and mid-sized companies are aware of these rules and regulations, right? Because in people's zest to promote their business, some will make mistakes. We're
Right.
trying to avoid anyone making mistakes.
Right.
The New York, New Jersey Host Committee has a toolkit that allows businesses to participate and use certain elements of some badges and images that are associated with the World Cup. And so businesses should contact the host committee and or the Meadowlands Chamber of Commerce, and we will direct you to that toolkit so we can do that. It's really about information and awareness. The more you know, the better you'll be.
Right.
Yeah. And so, Bill, so let's talk about a small business who zealously wants to promote their business. They don't know any about this. They use the FIFA logo, the World Cup logo. They go out there and they do that, and they get notification from FIFA that they're in some type of trouble. They need to cease and desist. What are the ramifications of that?
Well, the ramifications simply are you're going to have to stop. The money you invested in the advertising or the subject matter will have to be stopped. And you probably will be required to withdraw that subject matter and those ads from the market. So your investment will be lost. In addition, if you ignore the cease and desist letter, which some people have done, or even if you respond and say, well, it's not an infringement, you'll be sued. And you'll be sued probably in federal court in this area. And I assure you that litigation is very expensive, very time consuming, and will be drawn out.
At the end of the day, FIFA doesn't want to do that, but they have to protect their brand.
Exactly.
Right? And they have to protect what they've built in the World Cup. So businesses just need to know before they embark on that, spend the money on creative and all the advertising so that they don't have to take it down, they don't have to withdraw it, and create the kind of branding for their businesses that won't interfere with FIFA, but still allows them to market their company for when all these visitors come to our area.
Absolutely. Let's take a minute to talk about rights that you don't have. In the copyright field, many people think that if I hire an independent contractor and pay that contractor for the graphics or logos or content that the independent contractor has created, if I pay him, I own it, don't I? That is absolutely not the case. Because when copyrightable subject matter is created by someone who is not employed by you to create that subject matter, they own it and not you, even if you pay that person. So what do you need? You need a written copyright assignment. There's one other thing I want to mention. If your advertising depicts a building or a location, for example, you probably will need what's called a location release, because one of the intellectual property rights that can be enforced against you is the right of depicting a location and impliedly creating a connection between you and that location, which the location owner doesn't want. That also could lead to a risk. So Jim is absolutely right. Take the time, take a beat, count to 10, and say what rights are implicated in the advertising we have created and want to use.
And the point you brought up about getting some guidance before you pull the trigger is critical, right? Because if a company's going to spend the money on having a design firm design an ad and advertising, whether it's a still ad or a static ad or video, a digital video program, they need to check it out before they actually spend that money, before they pull the trigger. And it could save them thousands of dollars and the pain of having to redo everything that they thought was great. So Bill, AI is here to stay. Small and mid-sized companies especially are learning how to use it. How does a small business go about using it the right way?
Well, it's a difficult question to answer. Of course, if you see a piece of content created by AI, look to see if there are any notices of intellectual property protection within or associated with that content. For example, there might be a trademark notice, TM. There might be a registered trademark notice, a circled R. There probably will be a copyright notice, a circled C, with some language after it. But if you can't determine, if in doubt, don't. Because a lot of content generated by AI is anonymous, because what it has done is collect masses of information and provides them to you irrespective of who owns the information. As a result of that development, authors and copyright owners have filed class actions against the OpenAI companies for using their works to create content that ChatGPT or the like deliver to you. Remember that ChatGPT and other AI engines are open engines, meaning nobody has screened the content before AI pulls it all together and delivers it to you. So it's a very difficult question to answer, but at least knowing this, you can be prepared.
I got a good question for you, Bill. So let's say I'm learning how to use AI. I'm a small business and I don't have a graphic designer on staff or a videographer on staff, and I use some AI program to help me generate some images. And I generate some images and I create some video from that. Do I own that image? Do I own that video?
No. There are things that you combine to address Jim's question directly. Your video may be your content. You may own it. Why? Because you've had an employee do it, or you've had an independent contractor create the video and the contractor has assigned rights in the video. But if within that video you have used someone else's content, someone else's copyrightable subject matter, trademarks, or location, that can be called a derivative work and can still subject you to risks. In other words, when you prepare content using AI, you need to look at all of the separate elements and the genesis of each one of those elements, which is what I do when I review advertising.
So to further that, if I used Copilot or ChatGPT or one of the popular AI programs to create a caricature image of me, when it generates that image of me that I requested in my prompt, do I then get to use that and call it mine?
The courts haven't decided that issue yet, but it is probable that you can claim ownership in something like that. But again, if you use, for example, a cartoon character that AI has generated and someone says, well, I didn't let Jim Kirkos use that, that person can issue a cease and desist letter. So with that, we hope you have become more educated about the use of AI and intellectual property rights in general. It's not just about the World Cup. It's about anything you do in your business and advertising. Jim?
Yes, and remember, the most important factor is ask questions ahead of time, seek advice and guidance from organizations, from legal, and make sure you know before you pull the trigger.